city's arguing for in this case. And finally, you've got the issue of the direct dialogue with park enforcement officers. And the irony of the 30-foot restriction imposed by the city is it does precisely the opposite of what it seeks to do. In other words, it basically puts my clients in the position of having to yell at the park enforcement officers. It makes it almost impossible to have the type of dialogues that the court has heard on a number of the videotapes. Now, quite apart from that, again, the 8 feet, the 30 feet is clearly unconstitutional. In Hill versus Colorado, which is another one of the abortion cases, the U.S. Supreme Court upheld an 8-foot restriction, which I think is the largest footage restriction I've ever seen upheld in terms of direct communication. But that was 8 feet in the context of only within 100 feet of an abortion provider entrance and exit. There's been no suggestion that 8 feet would have survived if it applied to the whole downtown area of the municipality. So even in that restrictive sense, the most that's ever been contemplated is 8 feet. Now finally, defense counsel kept on challenging my clients about didn't they understand this was all about balancing your interests. And every time he asked my clients that question, I sort of regret the fact that I wasn't the witness stand, so I could have answered the question myself. Because the answer is clearly no, this is not the case about balancing interests. The Constitution is not just, constitutional rights are not just other interests that are balanced under the standards of various state tort laws. That's not the law, and it's never been the law. Now, finally, I want to respond to a question the courts asked at the end of the day yesterday, which is if the interference with contractual relations fails, is there any other claim to sustain the city's request for relief? Now again, the city will have to speak to whether they're even alleging a claim. It seems to me that there are only 2 conceivable claims beyond that interference with contractual relations. One is just the claim of equity itself. And I certainly acknowledge that equity is supposed to be broad and flexible. But it's supposed to be broad and flexible in bringing about vindicating a legal right. It's not supposed to be broad and flexible in creating a legal right. Otherwise, we've departed from a nation of laws and we're back to essentially pretty much unlimited judicial discretion. Now, in this case, basically what the city is arguing is we've got a hostile work environment, therefore we're somehow entitled to a remedy. Now, if that were the, I mean, my regular life, I'm an employment lawyer on the plaintiff side. If the city were correct, if a hostile work environment by itself merited some type of equitable response, I mean, that would revolutionize the law of employment. And that stands every principle of employment law on its head. And just another example of how they're seeking from the court to go well beyond the principles of law that have been recognized in the other context. And that's particularly improper in this case because we're dealing, understandably, with lay people who come to this proceeding with some level of distrust for government. And on one side, the other side, we're a body of government. And I think it's really important, that the court maintain its role of neutrality and not use the idea of equity to sort of step in there and create a legal right. And again, final point on this, I mean, to get to preliminary injunction, you have to show probability of success on merits. And to me, merits means there has to be some underlying legal claim to vindicate. Now, the final, the city has, as the court noted, the city has filed a damages claim as well, which is not technically before the court at this point. I will understand the city is trying to consolidate the case and protect the consolidation. The damage case makes the interference claim. It doesn't make a claim based on remedy. But it does add a new claim of negligence. makes the assertion that the defendants have a duty of care to government not to create unsafe working conditions for government employees. And I guess all I can say on that theory is that I think just stating verbatim makes clear how it is absolutely, utterly like any type of legal foundation. I mean, it's a complete, it goes beyond, in my opinion, it goes beyond creative lawyering to attempt to make something like whole cloth, which has no conceivable precedent, and really violates all of the existing principles here, particularly as they apply to the constitution of protected conduct. Your Honor, I have comments to make in terms of the injunction and the proposed remedy, but at this point, I think I would defer to the city to respond.
Attorney Barrett.
Thank you. Please the court, on behalf of the city of Keene, this court has a unique opportunity to fashion an equitable remedy that will strike a balance between competing interests. And those competing interests are the fundamental rights of speech, expression, assembly, videotaping, versus the interests of employment relations. You have the equitable authority to do justice. That's what equity is. To do justice, to do the right thing, to balance the interests of the competing interests that are involved, and to speak to the community, to bring peace and harmony, as you've heard, out to the streets in the city of Keene. And I would ask you to take a view of the parking meter situation when you have an opportunity. As an equity judge in this matter, you have an opportunity to create a win-win situation where these folks can continue to do all of the things that they want to do. Plug the meters, put the cards on the cars, do the saving of the tickets, and ultimately bring down the parking enforcement of the city of Keene, so long as they don't interfere, harass, taunt, intimidate, and cause an unsafe and hostile working environment that, at least for one employee, as you've heard, has been intolerable. Now, the question really is, that you've asked us to address, is a purely legal question. It is purely legal. It is not based on any facts that you've heard over the last 2 days, although the facts do give some context. But the legal question is, does the city of Keene, which is a corporate municipal corporation, have a right in an employment relationship with an employee? If you say no, as a matter of law, that will be the first time that an employment relationship between an employer and an employee has been determined to have no rights in that relationship. And if your answer is yes, that an employer, a municipal employer, does have a right in an employment contractual relationship with an employee, then the question becomes, the legal question becomes for you, does the employer have a right to protect that right, protect that employment right? And the answer is yes. I agree with my brother, and I agree with this court, that this is a purely legal question. It's a question of first impression. But it is not a major leap from the law that has been developed. The law that's been developed is that municipal corporations, such as the city of Keene, are treated as natural persons. They are, the municipal corporation is like any other private corporation. A a municipal employer is not treated any differently than a private corporate employer. And there's no dispute that a private corporate employer has rights in its employees, and it has obligations to protect those employees. It has obligations to protect those employees from working environments that are unfair, that are hostile, and that are unsafe. And a failure of a private corporation employer not to protect the employee does give rise to potential lawsuits by the employee. Intentional infliction of emotional stress, negligence towards that employee. So it is not just based on discrimination issues. Now, we believe that this court should find that the municipal corporation has rights in the employment relationship with its employees. And if so, then it has the right to protect those interests. If this court, because of the lack of case law out there, one way or another, my brother and I agree on a couple of things. One thing is that there's no case law that says that there is no such cause of action, and there is no such case that says there is a cause of action. But I believe, based on the precedent, that our position is not that far stretched from the private corporate employer situation. And if you think otherwise, if it's an open question of first impression in the state, maybe certification is the way to go. But I think this court can find, through the precedents that have been in the New Hampshire cases, that it is not a stretch. I firmly believe that if the issue is appealed, and it may be appealed or it may be certified, that the New Hampshire Supreme Court will certainly say that there is a right of a municipal corporation employer in its employees and a right to protect them. Otherwise, contracts for town managers and town administrators mean nothing if some other municipality or town wants to raid those employees. They certainly have employment relationships that have value. And in this case, you've heard evidence that the city has invested through the hiring process, the training process, the payments of money, the benefits, has invested in its employees. And those rights should be protected. What we're asking for in terms of this win-win situation is an injunction that burdens the speech no more than necessary than to serve the significant governmental interests at stake. And that's what the United States Supreme Court said in the case of Madsen and May-DSEN in 1994. And what Madsen said was that if it's narrowly defined, what Madsen says is if you identify significant governmental interests in the first instance, and in this case there are several, they've been outlined in our briefs before, but just to reiterate, significant governmental interest is promotion of public safety, public order, the motoring and walking public safety, the parking enforcement rules and regulations, the hiring and retention of city employees, and also the promotion of freedom of expression in terms of reasonable time, place, and manner restrictions. And if you find that there are significant governmental interests, and we think there are several, then this court has the power, according to the United States Supreme Court, to draft and fashion an injunction that will protect those significant governmental interests and not overly burden the rights of expression. And that is exactly what we are asking the court to do.
Let me ask a question. So I just want to make sure, and I want to let do you agree with Attorney Meyer's statement that if the claim for interference with contractual relations does not survive, that the case is over?
It's not a simple yes and no answer, unfortunately, for the court. And the reason for that is, certainly we have pled in the injunction action, intentional interference with contractual relations, which I've just addressed. You know now that some damage has occurred through the testimony, which had not occurred before. We tried to prevent that damage with the injunction, but it came too late. Now we have a foot in the legal arena as well, and there's not only intentional interference, but also a negligence claim. And this court may be familiar with the New Hampshire Supreme Court case of Hughes versus New Hampshire Division of Aeronautics, which was decided 152 New Hampshire in 2005, when the Superior Court judge found